Good evening everyone, welcome to Bajirao IAS Academy. So we have been discussing important topics for mains examination from polity subject, and in our previous classes also we have discussed parliamentary form of government, separation of powers and factors which have been contributing for the decline of parliamentary form of government, particularly functioning of the parliament, and we have discussed all these important topics. And today also we have another very important topic, that is parliamentary privileges. And in fact, there is a probability that a mains question can be asked from the parliamentary privileges as well. So we'll try to understand what exactly is these parliamentary privileges. And in fact, so Indian constitution has provided for the parliamentary form of government. So we have a parliament that constitutes both Lok Sabha and Rajya Sabha, and president is also an integral part of India's parliament. And in fact, in India, parliament is considered as a temple of democracy, and it is also considered as a pivotal institution for our democracy. And in fact, India is very often known as a functional democracy, and in fact parliament is a symbol of functional democracy in India. And in fact, as a cornerstone or as a political institution of our democracy, parliament actually enjoys a certain rights and immunities. Particularly when I say parliament, the members of parliament, so whether the members of Lok Sabha, members of Rajya Sabha, so they actually enjoy certain specific or special privileges. So they are rights, or they are also called as immunities, right? So these rights and immunities are called as the parliamentary privileges that the members of parliament actually enjoy, and these are known as parliamentary privileges. And when I say parliamentary privileges, Indian Constitution Article 105 talks about these parliamentary privileges. Now, what is the essence of parliamentary privileges and why Constitution has provided for these privileges is to ensure unhindered functioning of the House and also protect the rights of the members. So these are the two reasons for which the parliamentary privileges have been provided in the Indian Constitution. For the first, as we have already understood that it is a very important political institution, parliament. So therefore, since it is a very important political institution, so parliament should function in a unhindered manner, and apart from that, it is also important to protect the rights of the members of the parliament and provide them certain immunities. And that is the essence of providing or including these parliamentary privileges in the Indian Constitution under Article 105 of the Constitution. So in fact, we'll understand what are these parliamentary privileges and their evolution. Now, when we talk about the parliamentary privileges, they are essentially traced back to the Britain. And in fact, the parliamentary form of government that we have adopted is because of our colonial experiences, because Britain was actually the colonial master till 1947, and parliamentary form of government we have adopted from the Britain itself. So therefore, the parliamentary privileges also traced back to Britain. And in fact, the founding fathers of India or the framers of the Constitution have provided for absolute freedom of speech for the parliamentarians, right? So in fact, Indian Constitution Article 105 of the Indian Constitution, so it says that it actually provides for absolute freedom of speech to all the parliamentarians, right? So in fact, even citizens' freedom remained restricted, but they enjoy absolute freedom of speech. So they can say anything inside the house. So that level of freedom of speech has been extended to them. And in fact, in some judgments, the Supreme Court has also upheld the absolute freedom of speech provided to the members of parliament in those houses. And in fact, you can imagine the freedom of speech of members of parliament inside the parliament is much more than what citizens actually enjoy in terms the freedom of speech and expression that citizens enjoy. So it is much more than that. In fact, we also have reasonable restrictions on freedom of speech and expression. So but the members of parliament don't have such a limitations or restrictions, I would say, right? So that is what is known as absolute freedom of speech and expression. And in fact, So the founding fathers of India, so they actually vested the power in the hands of the parliament to codify these parliamentary privileges, right? So parliament actually can take steps to codify the parliamentary privileges. Now, as of now, we don't codify the parliamentary privileges. So there are other countries also like New Zealand, Australia, Canada. So what they did, they already codified the privileges. So when they codified the privileges, now there will be no confusion with respect to, so what are the privileges that the members are actually having. And so codification of privileges will also prevent the misuse of these parliamentary privileges as well, right? So however, the founding fathers of India have given the power to codify the parliamentary privileges to the parliament. However, so as of now, the parliament has not yet codified all the privileges that are being available to the members of the parliament, and that is one of the major problem. And in fact, law commission from time and again and several other committees have also recommended for the codification of parliamentary privileges on the lines of countries like UK, Australia, New Zealand. So that is very, very important. And in fact, if you look at the current scenario of parliamentary privileges, what we could actually observe, right? So in fact, as we have already understood that the parliamentary privileges, it actually provide absolute right to freedom of speech and expression for the members in the house. And apart from that, the parliamentary privileges also extend all the parliamentarians that they can enjoy immunity from the arrest during the session. For example, whenever parliamentary session has been taking place, so no member of the parliament should be arrested, and in fact prior to that session also no member of the parliament can be arrested. So this is to prevent the arbitrary nature of the government, right? So understand one thing, that if a no confidence motion has been introduced against the government, and so if that no confidence motion has been passed, so then government has to resign, the council of ministers has to resign. So therefore, in this context, so such immunities have been provided to all the members, that while parliament is in session, no member of parliament shall be arrested, and no member of parliament should not be arrested, so 40 days prior to the parliamentary session as well. So therefore, it effectively extends immunity to the members of the parliament. So in fact, in recent times we have seen parliament has been slapping privileges on citizens, civil servants, journalists, and it is very, very commonly observed, right? So particularly the contempt of parliamentary privileges. Now, what is the importance of parliamentary privileges? Now, why we are actually talking about that? There are some reasons because of which we have to consider parliamentary privileges are very, very important for the effective and unhindered functioning of the parliament. Now, firstly, so it actually ensures functionality. Now, how it could actually ensure functionality? Now, when we talk about functionality, privileges such as freedom from arrest, freedom of speech and expression, so they actually exist. The house can perform its functions without any hindrance. Now, whenever such rights are extended to the members of the parliament, so the house can actually function much more effectively without any hindrance. And apart from that, protection of members is also another major reason why these parliamentary privileges have been extended. And in fact, the power to punish for the contempt of the house, and the power to regulate its own business. So any house, it can regulate its own house, and no other interference should be allowed. So therefore, it exists for the protection of members and also vindication of house authority and dignity as well. So remember, as we have already discussed, that it is a very important political institution. It is considered as a cornerstone of democracy. So therefore, parliamentary sovereignty has to be ensured It is very important to maintain House's authority and dignity as well. And in fact, parliamentary privileges are also provided to prevent external interferences in the functioning of the parliament. So that is also very, very important, because parliament means the legislative wing of the government. And in fact, so we have a separation of powers. So because of the separation of powers, so no other body of the government should interfere in the functioning of the legislature. Now what legislature would do? Legislature enact laws, right? So therefore privileges are actually granted to enable the legislators to carry out their duties without any fear or favor, and also prevent the external interferences from the other branches of the government. And what are the issues with the parliamentary privileges? Now why there's a debate around the parliamentary privileges, so we'll try to understand that particular aspect as well. And in fact, the parliamentary privileges very often comes in conflict with the fundamental rights, right? So we could also say that it comes in conflict with the constitutionalism. So how it comes in conflict with the constitutionalism, we'll try to understand this, because the power of legislators to be the sole judges of their privileges and breaches undermines the constitutionalism, right? So it actually provides exceptional powers to the parliament, exceptional powers to the members of the parliament. So this actually resulted in legislators becoming sole judges of their own privileges, and it also undermines constitutionalism. And in fact, there are reports of misuse of these privileges which are being provided to the members of the parliament, right? Because we have seen instances of misuse of these parliamentary privileges. In the year 2017, there was a case where 2 journalists were imprisoned on the order of the Karnataka Assembly Speaker, and that thing has been raising a lot of concerns. So it is not one incident that happened. There are several such instances also, where the privilege or the content has been slapped on journalists, civil servants, citizens. So therefore it is a matter of concern, particularly the misuse of the parliamentary privileges. And the legal experts also argue that the parliamentary privileges is a contradiction with the rule of law. Now how it is a contradiction with the rule of law? Because Article 19 of the Indian Constitution provides for freedom of speech and expression, right? So in fact, Article 105 of the Indian Constitution also grants absolute right to freedom of speech and expression. So therefore here the absolute freedom of speech granted to parliamentarians, it seemingly places them above the citizens. So it seems like parliamentarians are above the citizens, and in fact it is considered as a point of contention with our democratic principles, because parliamentarians are given primacy over citizens when it comes to the right to freedom of speech and expression, which has been granted to both parliamentarians and the citizens as well. And in fact, the parliamentary privileges are also criticized on the ground that they could be considered as a threat to the principle of equality or concept of equality, because Article 105 of the Indian Constitution, it talks about the privileges to the members of the parliament. It actually grants certain rights and immunities to the parliamentarians, and of course it undermines the concept of equality under Article 14 of the Indian Constitution. So Article 14 of the Indian Constitution talks about what? It talks about right to equality and equal protection of law. Equal protection of laws. So this is what Article 14 talks about. However, legal experts have been advocating, or they are arguing, that it can be considered a threat to the principle of equality. And in fact, the privileges, parliamentary privileges, are also immune from judicial review, or we can say they are also immune from the court review. Why? Because we have understood that the parliamentary privileges would prevent the interference of other organs of the government in the functioning of the legislature, and therefore these parliamentary privileges actually provide immunity from the court review. So that essentially means that court cannot intervene in the functioning of the parliament. So even if the privileges or contempt of the house are arbitrarily or in an unjust manner imposed on a particular individual, journalist, or even civil servant as well. So therefore, the most controversial aspect of these parliamentary privileges is that power and jurisdiction of courts to review parliamentary privileges. So courts are power to review these parliamentary privileges is restricted or limited. And in fact, as I have already told you in the beginning of the class, that there are some countries which actually codified all these privileges. For example, I told you that US has codified these privileges, New Zealand codified privileges, Australia also codified privileges, and even for that matter UK also codified these privileges. And there are a lot of commissions which have been recommending codifying all these parliamentary privileges. Now codifying all parliamentary privileges would result in what? It would prevent misuse of the parliamentary privileges, and that is very, very important, right? So it would prevent misuse of parliamentary privileges. So however, the problem is that as of now the legislators are not interested to codify the parliamentary privileges, and that's where these parliamentary privileges are being very often in debate. So therefore, in this context, it is very important that all these privileges must be balanced with the fundamental right of citizens, such as free speech, right? So there should be a balance between the free speech, which is a fundamental right of citizens, and the parliamentary privileges, and that is very, very important here, because there's a conflict between the fundamental rights of citizens and the parliamentary privileges enjoyed by the parliamentarians. So therefore, the privileges which are essential for independent functioning of parliament, so they often come in conflict with free speech, and that results in paradoxical situations. And in fact, Supreme Court initially actually gave primacy to the privileges over free speech in M. Sharma case. So in this particular case, the Supreme Court has actually given primacy to the parliamentary privileges over the individual fundamental rights. So however, later the Supreme Court has reconsidered its earlier stance on the supremacy of the parliamentary privileges over the individual rights. So in this context, what should be the appropriate way forward? So we should also discuss an appropriate way forward as well, and that is very, very important here. So codification of all parliamentary privileges is very, very important, because we have already understood that there are other countries also which already codified all these parliamentary privileges. For example, US, New Zealand, Australia, UK. So all these countries already codified parliamentary privileges. So as I have already told you, codification of parliamentary privileges prevent misuse of the parliamentary privileges, and it would further enhance accountability of the legislators, and it would also open these parliamentary privileges for the judicial scrutiny as well, right? So codification is very important for parliamentary privileges. And apart from that, we could also learn from the global experiences. So how we could learn from the global experiences? Because already a number of other countries such as Australia, USA, New Zealand, Canada, so they already codified all parliamentary privileges. So they could actually serve as a model for India as well in codification of the parliamentary privileges. And so whenever you write any answer on the parliamentary privileges, in conclusion itself, you could actually write that parliamentary privileges are very, very important for the smooth functioning or effective functioning of the parliament, or functioning of the parliament without any hindrance, right? Because parliament is considered as a cornerstone of Indian democratic polity or India's democratic polity, and it is a symbol of India's functional democracy. However, the problem with the parliamentary privileges is that they are undefined, they are not codified, so they may give unchecked power to the parliament or the legislators. So therefore it could very often lead to the potential misuse and also infringement upon the citizens' rights as well, that we have just discussed. So therefore in this context, what we could actually write, so there is a need to balance the parliamentary privileges with the individual citizens' rights, and that is very, very important, and that's how you could actually approach this aspect of parliamentary privileges. Next, role of opposition. So opposition is also a very important component of the parliamentary form of government, particularly in India, but recently we have seen the decline of opposition. Now opposition actually plays a very important role in any democracy, because opposition can hold the government accountable, it can hold the executive accountable, so it could actually create a larger public opinion about major national issues. So but in recent times we actually see the decline of the opposition. So in this context, in this backdrop, this is also a very important topic, so we'll try to understand this dimension as well. And in fact, the essence of any vibrant democracy, now India is considered as a vibrant democracy because we don't have one party system or two party system, we have a multi-party system. So we have a multiple parties, and everyone are given right to cast their vote irrespective of any distinction. So therefore India is considered as a vibrant democracy, and in fact it lies in the constant churning of diverse viewpoints. And since it is a vibrant democracy, so we also ready to accept vibrant or diverse viewpoints, with opposition playing a pivotal or a very, very important role with respect to the parliamentary form of government or in democracy, or further enriching India's democratic values. However, a strong opposition in any country stands as a necessary counterbalance to the ruling party. It is true because opposition plays a very important role in holding the government accountable, holding the executive accountable. So therefore it is very important, I would say, to counterbalance the existing ruling party. And in fact, when there is a strong presence of opposition, we could also say that there is a plurality of voices in the sense that the opposition political parties and members of the opposition political parties started constructively criticizing the government policies. And that is very important. Government would actually look into this constructive criticism, and it actually provides an opportunity for the government to come up with appropriate policies. And it would also prevent majoritarianism. It would also prevent framing the arbitrary nature of the policies. So that kind of a huge role that opposition actually plays in any democracy. So therefore, opposition political parties play important role in upholding democratic principles, ensuring India's democracy remains a functional democracy. And that is very, very important here. And now we'll understand the role of opposition in Indian democracy. So what role we actually envision for the opposition in the Indian democracy, in the Indian parliamentary form of government. And in fact, so opposition political parties very often act as a voice of the voiceless communities, right? So one example of opposition political parties acting as a voice of the voiceless communities, or the voice of the marginalized, deprived, backward classes, is that extension of Pradhan Mantri Garib Kalyan Ann Yojana during the national lockdown. So because of the criticism of the opposition political parties, the government has decided to extend PM Garib Kalyan Ann Yojana. So this is a scheme which is which actually involves distribution of food grains free of cost to all eligible beneficiaries, particularly the BPL families, right? So under National Food Security Act, right? So even after the lockdown ceases to exist, then also free food grains have been provided to the people under PM Garib Kalyan Ann Yojana. And in fact, so as I have already told you that opposition political party and opposition political party leaders play a very important role in holding the government accountable. So they ensure accountability. They hold the government accountable for their actions, for their decisions, and the policies and the programs that they have brought in. For example, I hope you knew about Lokpal and Lokayukta. So Lokpal and Lokayukta are the anti-corruption bodies that were brought in. And in fact, after 2010 and even before 2010 also, a lot of political parties have consistently supported for such anti-corruption bodies so that corruption in India could be eliminated. So therefore, opposition political parties can actually increase pressure on the government. So they can also act as a pressure groups, right? So they also mobilize the voices of the people. However, in India, opposition political parties have been facing number of issues. So we'll try to understand what are the issues that opposition political parties have been facing. Now, the one major problem is that if you look at the opposition political party, right from the 16th Lok Sabha, 17th Lok Sabha, the problem is that the opposition political parties lack the required strength, right? So because if any political party is to be recognized as the opposition political party, so it must get at least 10% of the seats in the Lok Sabha. So only then that political party will be recognized as the next big party or the opposition political party, right? So parties like Indian National Congress lack the numerical strength to challenge the ruling party effectively. So this is one issue that the opposition political parties have been facing. And in fact, these opposition political parties also lack unity among themselves. So they very often divided on party lines. They also lack the inter-party democracy as well. Intra-party democracy, inter-party democracy, and they are divided on the party lines, and they are also divided on regional interests. And in fact, many remaining silent on issues outside their political parties, outside their interests. So this is another major problem that has been plaguing the functioning of the opposition. So that has been impacting the effectiveness of opposition counterbalancing the government. And in fact, defection is also another major problem here, because prioritizing self-interest over national interest, and this leads to political defections and weakening role of opposition political parties. And in fact, in order to arrest defections, in order to prevent horse trading, 52nd Constitutional Amendment Act has been brought in, and 52nd Constitutional Amendment Act has added 10th schedule to the Indian Constitution, and 10th schedule deals with the anti-defection law, right? So we'll discuss about the anti-defection law and its major provisions as well. Now, what will be the consequences of having a weak opposition in any country? Now, in fact, Indian society is considered as a democratic society, right? So Indian society is a democratic society, but the weak opposition, so we have been seeing weak opposition in last two Lok Sabha, whether it is 16th Lok Sabha, 17th Lok Sabha, we actually see a weak opposition. So opposition not even got the required numerical strength to become the major party after the government. So therefore, the problem is that weak opposition can actually impact the democratic nature of India's society, because it is being evidenced from democracy index that is released by Economic Intelligence Unit, and the democracy index has tagged India as a flawed democracy. Right, so this is the first major consequence of a weak opposition in any country. And secondly, we should also talk about tyranny of the cabinet. And in fact, whenever opposition is weak in any country, so that would leads to more concentration of powers with the cabinet, and that we have already seen when Indira Gandhi was Prime Minister of India. So therefore, history actually shows us when opposition weakens, opposition lacks numbers, the cabinet started strengthening, and that leads to protests like student protests, Citizen Amendment Act protests, and even the farmer revolt as well. And in fact, so weak opposition would also impact governance structure. So therefore, discontent among masses due to unpopular bills and acts can actually lead to insensitivity towards administration and even disrupting the governance architecture as well. Right, so these are the consequences of having a weak opposition in the country. Now, what are the reforms that are actually required in this context? So we should also discuss some reforms so that the opposition in India would be much more stronger, and it could actually hold the governments accountable, and it could become voice of the voiceless as well. So when we discuss reforms, first we need to talk about the legal reforms, and that have to be taken into consideration. Right, so in situations where no party in opposition secures 10% of seats or 55% or more seats, so numerically largest party in the opposition should be recognized as a leader of opposition by the speaker. So this sort of a reform that we actually brought in, because whichever party gets 55 seats in whichever party gets 55% seats, or otherwise it is also known as 10% seats of Lok Sabha, so that political party is recognized as the opposition political party in the Lok Sabha. But the problem is that no party in previous Lok Sabha have got such a numerical strength. Right, so it also creates problems such as lack of effective or strong opposition political party. And in fact, there is a need to change this 10% numerical strength as well. Right, so 10% formulation is considered as inconsistent with the Salary and Allowances Act that has been framed in the year 1977. So this particular legislation suggesting that largest opposition party should actually get the post instead of having this 10%. And when we have this ceiling of 10% or 55 seats any political party must win, then in that particular aspect, what has been happening, so in case no political party gets 55 seats, that leads to lack of opposition, and opposition in any democracy is very, very important. So therefore, there is a need to revise or reform this 10% ceiling as well. And in fact, national interest, because as we have already discussed, the opposition political parties are divided on party lines. So opposition political parties are divided, or they actually look after their own political party interests, their own personal interests, and these political parties lack inter-party democracy and intra-party democracy also. And because of huge dominance of the party issues within these political parties, so they are not able to look beyond the party interests, because regional interests and national interests are also very, very important. So when these political parties started taking up the national issues, then they could actually play a huge role as an opposition political party, and people's trust on these political parties can be further strengthened when they start looking beyond their narrow political ideologies or interests as well. And in fact, It is also one of the major reform that has been suggested time and again to further strengthen anti-defection law, right? So this is 52nd Constitutional Amendment Act, so further strengthening anti-defection law, because revisiting the anti-defection law can actually help curb political defections, and it could also strengthen the role of opposition political parties, and that is the idea when it is suggested to further strengthen the anti-defection law. So however, ultimately when we talk about the opposition political parties, so no doubt that opposition in any functional democracy is very, very important, right? So it plays a very, very important role in parliamentary democracy of any country, particularly for India. So however, we need to borrow best practices such as UK's shadow government or shadow cabinet, UK's shadow cabinet. So that could actually potentially invigorate India's opposition. So that is vital for thriving Indian democracy. So next topic is the role of president and governors as part of the legislature. So we'll also try to discuss this as well. So what role president and governor would have as part of the legislature? Because one thing that we need to understand, so when we say that the Indian Parliament, so Indian Parliament actually consisting of Lok Sabha, it also consists of Rajya Sabha, and along with Lok Sabha and Rajya Sabha, president is also considered as an integral part of the parliament, right? So he is also considered as an integral part of parliament, and even president is also known as head of the executive, right? So why president is considered part of parliament? Because if any legislation is to be passed, so that particular legislation can be introduced in either Lok Sabha or Rajya Sabha, and once this legislation gets the approval of both houses of the parliament, it goes to the president for his assent. So it will not become a legislation until president gives his assent to the bill, right? So because of that reason, president is considered as an integral part of the parliament. And even with respect to constitutional amendment also, so it will not become a full-fledged constitutional amendment if president don't give assent to the constitutional amendment provision, right? So he is also considered as head of the executive. Now how president is an integral part of the parliament, and even governor is also considered as an integral part of the state legislature, that thing you should understand here. So he is also considered as an integral part of the state legislature. Now we'll understand role of president as part of the legislature. So what role president actually have as a part of the parliament or legislature? We already discussed about this, that president actually performs certain legislative function. So what sort of a legislative function that president performs? Under Article 123 of the Indian Constitution, president actually issues ordinances, right? When both houses of the parliament are not in session, under Article 123 of the Indian Constitution, president can actually issue ordinances, right? So in fact, this is considered as a legislative function of the president. And in fact, apart from this legislative function, president also perform other legislative functions, such as president can actually summon the house, prorogues the house, and he can actually dissolve the parliament based on the advice tendered to him by the prime minister. Or even president can actually dissolve the Lok Sabha when not Lok Sabha, president can actually dissolve the council of ministers, or can ask the council of ministers to resign when the council of ministers lost the confidence of the lower house as well, right? So in fact, president also performs certain judicial functions as well, right? So what judicial functions that president actually performs? In fact, president can actually disqualify MPs, member of parliament, on the recommendations of the Election Commission of India. So on the recommendations of Election Commission of India, president can actually disqualify the members of the parliament, right? For example, if any member of parliament holds office of profit, right? So if anybody holds office of profit, so then also a member of parliament can be disqualified, undischarged, insolvent. So in all those cases, president has the power to disqualify MPs. And in fact, president can also have a control over the legislation, because president's recommendation is needed whenever whenever the executive is introducing money bills, right? So whenever executive is introducing money bills and bills which are related to Article 3 of the Indian Constitution. So Article 3 of the Indian Constitution talks about bifurcation of the states, and merging two or more states or one or two states, so something like that. So therefore, bills which deal with Article 3 of the Indian Constitution, money bills, and even withdrawing money from the Consolidated Fund of India, and this could be considered as a money bill. So in all those bills, approval of the president is required before introducing those bills in the parliament. And in fact, so we also knew that president also addresses the house, right? So when president addresses house, and in fact, president may address either or both houses, and he also delivers an address at the first session after every general election. And first session every year also, president actually gives address to the either or both houses of the parliament. And in fact, president also have nomination powers, right? So he also have the nomination powers, as he nominate 12 members, right? So he nominate 12 members to the Rajya Sabha. So he actually have the power to nominate 12 members to the Rajya Sabha from fields such as art, literature, science, and social sciences, right? So in these areas, president can actually nominate 12 members into Rajya Sabha. And now we'll understand what is the role of governor as part of the state legislature. So similar to the president, governor also have a certain roles and responsibilities at the level of state legislature, and we'll try to understand that aspect as well. Now firstly, like how president can actually looks after the business of the house. In a similar way, governor from time to time, he could actually summon the house, and he could prorogue the house as well. After adjournment, sine die announced by the speaker of the house, and governor can also dissolve the house on the recommendation or on the advice of the chief minister of the state. And in fact, governor can also remove the council of ministers when he felt that the council of ministers lost confidence of the house, right? So this is how governor actually performs certain legislative functions. And he also nominate members to the state legislative council, right? So he also given the power to nominate members to the state legislative councils. And understand one thing here, that all states don't have the legislative councils. Only few states have a legislative councils. And in fact, if any state wanted to have a legislative council, it has to pass a resolution, and the resolution has to be sent to the parliament. So parliament, through a constitutional amendment, either create or abolish the legislative council for that particular state. However, Indian parliament is bicameral in nature, but at the federal level, at the state level, not federal level, at the state level, it is not a bicameral legislature. So it is not mandatory that we should have a bicameral legislature at the provincial level or state level. And in fact, so governor also have the powers to disqualify members of the state legislature on the recommendations of the Election Commission of India. So he can actually disqualify both member of Legislative Assembly and member of Legislative Council if they hold any office of profit. And in fact, governor also have a certain special powers, such as, for example, whenever state legislature passes a bill, now then the bill goes to the governor for his assent, right? So now governor will have options with him. The options are either the governor can give assent to the bill, first option. Second option, governor can actually send the bill back to state legislature for the reconsideration, or governor can actually reserve the bill for the consideration of president, for presidential consideration, right? So if governor felt that any bill that has been passed by the state legislature is threatening the position of High Court, and it is conflicting with the existing directive principles of state policy, and any bill which is against India's constitution, constitutional ideals, principles, so in those cases governor have the discretionary power to reserve bills for the consideration of the president. And in fact, like how president has the ordinance making power when both houses of the parliament are not in power, in a similar way article 213 of the Indian constitution provides governor with a power to make ordinance, right? So governor can actually pass ordinance when the state legislative assembly is not in session. However, in order to meet the urgency of that particular situation, so ordinance is being passed by the governor on the advice of the Council of Ministers. However, the Supreme Court a number of times held that ordinance is subjected to the judicial review. And similarly, governor also have the power to lay down certain reports. For example, State Finance Commission has been constituted, and State Finance Commission submit its report to the governor, and apart from that, State Human Rights Commission. So governor actually causes reports to be laid before the state legislature. So those are the roles and responsibilities of the governor and the president. And in fact, as we have already discussed, that these roles and responsibilities of the governor and president, they form a very important part in legislature, and in fact they are considered as an element, or they considered as a part of the legislature, and it is said that they are the cornerstone of Indian parliamentary democracy. However, so despite not directly participating in the legislation, their influence is very significant, and it has to be exercised judiciously, the ordinance making power or their discretionary powers. So they have to exercise their duties, their responsibilities judiciously in upholding the democratic values. They should not be guided by the narrow political interests or personal interests, but they should uphold the democratic values. They should uphold the constitutionalism in India. Right, so I hope you have understood this, and now we'll try to discuss the socio-economic profile of parliament. Right, so right after independence now, so who are the different categories of people represent, for example, when I say socio-economic profile of the parliament, so it takes into account region, and it takes into account caste, religion, it takes into account ethnicity of the people, and it also takes into account educational qualification, and gender differences, economic status. So everything would come as part of the socio-economic profile of the parliament. So we'll try to discuss this aspect as well. Right, so just as a mirror reflects individuals, like how a mirror actually reflect individual, a country's parliament also embodies the collective ethos and aspirations of its entire society. Now it is very important that it is very important to understand whether Indian parliament is completely dominated by some wealthy sections, completely dominated by the upper caste. So Indian parliament has more representation from one particular region compared to other regions. So it is very important to understand the overall socio-economic profile of the parliament as well. Right, so right after independence from 1947 to 1967, so what was the socio-economic profile of the parliament? So the socio-economic profile of the parliament was, during these 20 days, Indian parliament was heavily dominated by representatives from Brahmins and other backward classes, and in fact women are significantly underrepresented in this particular phase. So apart from that, in these 20 years, the socio-economic profile of parliament predominantly consisted of foreign university graduates, mostly lawyers, which are being followed by the agriculturalists as well. So second phase from 1967 to 1989. So what changes we could actually observe in the socio-economic profile of Indian parliament in this particular period? And in fact, this period is called as democratic upsurge. Right, so this period is called as what? So this is called as democratic upsurge, because in this period we have seen the consolidation of the other backward classes, and because of this particular reason, so we could call this phase is called as democratic upsurge. And why there is a rise of other backward classes, so consolidation of other backward classes? It is because the Green Revolution is one reason. And apart from Green Revolution, land reforms is also another major reason. So Green Revolution and land reforms have led to the consolidation of other backward classes. And in fact, OBC's representation in the Indian parliament has been substantially included with agricultural, social workers. So they are emerged as a major profession in the Indian parliament. Now, if you look at the third phase of the Indian parliament, that has been started right after 1989. So we could say that it is more diverse in nature, and in fact it is also termed as a plebeianization phase, because it marked OBC's dominance and in fact a huge influx of business personalities into politics. Now, right after 1991 economic reforms, now what happened? Economic reforms, LPG reforms, a new opportunities unfolded. right? After LPG reforms, new opportunities unfolded and inequalities have increased. And in fact, a lot of people who are skilled, who are having the financial support, so they become successful entrepreneurs, and that become a solid foundation. And then so they started entering into the politics. So this phase has seen the influx of business personalities into politics and an increase in individuals from business profession, rising from 23% in 2014 to 29% in 2019. Right? So people who are having business as a profession, and their presence in the Indian Parliament has substantially increased after this particular period. Now, whenever you write an answer, it is very important that you should mention this impactful data along with your answer. So this phase has also witnessed criminalization of politics. We have seen more than 40% of the parliamentarians have criminal cases pending against them. So after 1989, criminals are started entering into politics and they became parliamentarians, and a trend of criminalization of politics has started. And in fact, in the 17th Lok Sabha, 38% of the MPs are agricultural background, 39% of the MPs are social workers, and 29% are actually the business personalities. And in fact, the 17th Lok Sabha actually sees 90.4% of the MPs being Hindus, 5.2% are being Muslims, and rest are Sikh and Christian. So this is how the socio-economic profile of parliament actually looks like, right? So in fact, this phase is also known as the plebeianization phase, and we also started seeing people from different backgrounds, people from different communities becoming the parliamentarians. So however, in terms of proportion of their population, Muslim MPs are still less, because they constitute just 5.2% only. Now next we'll understand about criminalization of politics. Now in India, criminalization of politics is a major issue, right? So what exactly is a criminalization of politics? First we'll try to understand this, right? It is very important to understand. So criminalization of politics essentially means that involvement of the criminal elements in politics. So criminals are entering into politics. So criminals are also having the higher chances of getting elected, and because of that reason, the political parties are also very often favoring giving tickets to the people who are having criminal background, because they can use the money power and muscle power, and because of that reason they have a more chances of getting elected. And that's why the political parties have been encouraging entry of criminals into politics. So criminalization of politics is involvement of criminal elements in politics and a subsequent election as a representatives, and that is being referred to as criminalization of politics. And this is very important. Remember, whenever you are being asked any question on criminalization of politics, first you need to mention this definition. And after mentioning the definition of criminalization of politics, so you need to write this data about the criminalization of politics. So according to Association for Democratic Reforms, around 24% of the Rajya Sabha members have been facing criminal cases against them, right? So whatever data is available with respect to criminalization of politics, it is better to mention such data. However, it is important for us to understand the factors which have been contributing for the criminalization of politics. And in fact, there are a lot of issues which have been contributing for the criminalization of politics. So vote bank politics, or I would say increased use of religion in politics, money power, muscle power, it is also known as money muscle men nexus, legal loopholes which are existing, lack of fast track courts to try and convict politicians who are having serious criminal cases against them, and lacks implementation of the model code of conduct or violation of the model code of conduct, and limited awareness among the people, lack of governance and corruption. So all these are the major problems that are existing and that are making dealing with the criminalization of politics very, very difficult, right? So what are the criminalization effects of free and fair elections? So that is what we should understand, right? So whenever the free and fair elections are being criminalized, so it impacts good governance and it impacts the integrity and honesty of the public servants. An unholy nexus would develop, right? Unholy nexus among bureaucrats, politicians, politicians and corporates. So this is known as the unholy nexus, right? So it also dent the public faith and trust on the judiciary, and it also affects the societal harmony, and it also presents a poor image of the nation to the international community. So these are the problems with the criminalization of politics. So in this image you can actually see what are the causes of criminalization of politics, such as factors like vote bank politics, manipulation, increased use of religion, corruption and community interests. So all these factors have been contributing to the criminalization of politics. So implications of criminalization of politics include, it undermines free and fair elections in India, it undermines good governance, it undermines public trust, public confidence on judiciary, and it also paints a poor picture of India at the international stage. And what legal responses that we need to adopt? So legal frameworks and court rulings attempt to address criminalization, so they are very often insufficient. And in fact, fast track courts, special courts are not constituted to try cases which involve politicians and convict them, right? So despite several judgments from the Supreme Court, such as Lily Thomas judgment, so there are several cases. So despite then, the fast track courts are not properly established. These fast track courts lack necessary infrastructure as well. So therefore, what solutions are required in this context? So solutions include empowering the Election Commission of India, anti-defection law, and empowering in the sense that giving more powers to Election Commission of India is very, very important, and public awareness is also very, very important about the ill effects of the criminalization of politics. Intra-party democracy has to be promoted, and that is also a very, very important thing here. And what measures that we could actually take in this context, right? A set of measures could be taken. So before discussing them, so there are some important Supreme Court judgments on the issue of criminalization of politics, right? So what Supreme Court judgments are there? For example, Lily Thomas versus Union of India judgment of 2013. So in this judgment, the Supreme Court has held that MPs and state legislature which convicted of a crime with a minimum sentence of 2 years, of imprisonment, would cease to be members of that particular house. And Public Interest Foundation versus Union of India. So Public Interest Foundation versus Union of India 2018 judgment, the Supreme Court has held that a person cannot be disqualified from a membership in a legislative body on mere framing of criminal charges against them. So just by framing criminal charges, any person cannot be disqualified as a member of the legislative body. So these are two important judgments of the Supreme Court with respect to the criminalization of politics. And you could also see how the trend of criminals entering into politics has been increasing, right? So in 2004 24%, 2009 30%, 2014 34%, and 2019 it is 43%. So the number of criminals entering into politics have been substantially increasing. So however, there are certain measures that have to be adopted, such as ensuring transparency, promoting citizens awareness about this, and providing statutory status to the implementation of the model code of conduct reform, providing more powers or empowering the Election Commission of India with respect to deregistering the political parties, not just registering the political parties but deregistering the political parties, more independence to the Election Commission of India, and the expenditure of the Election Commission of India should be charged upon the Consolidated Fund of India so that it will not be subjected to voting. And Election Commission of India should appointments of election commissioner and chief election commissioner should be made independent of the executive, and in fact de-recognizing the parties which are supporting the criminals, and establishing fast track courts, and try cases in a shorter period of time, award conviction to the criminal politicians, breaking the criminal politician nexus, and also demonstrating political will. So all these measures have to be adopted to deal with the trend of criminalization of politics in India. And another very important topic, so that is low participation of women in politics. So we will also understand about the participation of women in politics. What are the reasons for a lower participation of women in politics? What are the measures adopted by the government for increasing participation of women into politics? So first of all, we just look into the data of participation of women in politics. So India's ranking is concerning with respect to participation of women in politics, because India ranked 153 out of 190 countries according to this Inter-Parliamentary Union, right? Particularly with respect to participation of women in politics, because in Lok Sabha, women constitutes just above 14%, near to 15%. So this is substantially lower than most of the underdeveloped countries or developing countries. However, the state legislatures also have such a low representation of women. So they also represent a bleak picture when it comes to participation of women in politics at the level of state legislature, because the average is only 9%, just 9% of the women representation in most of the states. However, Bihar and Rajasthan are progressive when it comes to participation of women at the state legislature level, because both states have a representation of around 14%. Now, what are the challenges which are actually withholding women's participation in the parliament, right? So there are certain challenges which are actually hindering women's participation in parliament. For example, the patriarchal influence, right? So we are living in a patriarchal society, and India is known as a patriarchal society. So the pervasive influence of male members in making decisions at the level of family and beyond family, so that actually overshadows power held by women, and that is significantly visible in Panchayati Raj system through a phenomenon of Sarpanch Pati. And we knew that the 73rd and 74th Constitutional Amendment Acts, so they have provided 33% of the reservation for women in panchayat and municipalities. But when we talk about the panchayats, even though 33% of the seats are reserved for the women, on behalf of women, the male members of the family would take up the responsibility as a sarpanch. So this is what is known as the Sarpanch Pati system, and that reflects the patriarchal nature of the Indian society. And in fact, identity masking is also another major problem when it comes to participation of women in politics. So women candidates often win elections based on their political party affiliation rather than being elected on their own identity. So they are being elected on the identity of the political parties, on the identity of the male members or the most influential members of their family. So thereby it has been masking their individual identity, and that is another major challenge that women have been facing. And in fact, they also have certain attitudinal barriers as well. For example, certain beliefs which are prevalent in the society, and in fact, so those perceptions are actually stereotyping women's capabilities as a political leaders, because this is being illustrated by the instances where women legislators have been disparaged for fulfilling their duties. And apart from that, low awareness level is also another major problem when it comes to women representatives. So female literacy in India lags behind that of men, and 65% versus 82%. So that has been hampering women's general awareness and even confidence as well. And in fact, work-life balance is also another very important area. So work-life balance. So domestic responsibilities, societal expectations of women, so they can often interrupt their political aspirations. And even financial constraints is also another major problem. So economic dependency and limited access to resources act as a substantial impediment to women's political involvement. So these are the problems that women have been facing. So you can also go through other factors which actually which actually create challenges for women's participation in the politics, and they also challenge the political empowerment of women. Now, what is the significance of women in the decision-making bodies, right? So when we talk about the significance of women in decision-making bodies, so it would result in efficiency in the governance whenever women representatives, because countries which are led by women, such as previously Germany, New Zealand, so these countries have demonstrated a condemnable efficiency, including effective pandemic management as well. Right? So gender sensitive approach, because it is felt that the female legislators often focus more on women centric issues, and they work for the welfare, development, empowerment of women, and they actually play a very important role in addressing issues such as sanitation and self-help groups, and this would further leads to improved health, hygiene of women, improved nutrition for the woman. It reduces infant mortality rate, it reduces maternal mortality rate, and self-help groups would make women entrepreneurs, so they become financially independent, right? So financial empowerment of women would further pave a way for the political empowerment of women. And in fact, the role of women in international relations, negotiations, diplomacy, so it is also effectively recognized, because it is being believed that women actually play a very, very instrumental role when it comes to conflict resolution in the international negotiations or international relations. And even enhanced responsiveness. So when we talk about enhanced responsiveness, female leaders have proven to be more responsive to the needs of disadvantaged groups, including prompt action on crimes against women and breaking the cycle. So breaking the cycle, encouraging more women to participate in politics, so that can help break the cycle of socioeconomic disadvantages which are being faced by the women in the Indian society, right? So how giving more representation to women will actually help build an equitable, healthy, society. So in fact, women have a diverse perspectives, because women experience different forms of discrimination and other social challenges that women have been facing. So therefore, women can actually contribute to better sensitivity towards gender related matters and also the broader understanding of the existing social issues. And in fact, equity and inclusiveness is also another major dimension, right? Because when we provide equal opportunities for women, when we bring in gender equality when it comes to participation of women in politics, so that would help break barriers and stereotypes that have traditionally limited the true potential and progress of women in this area. And in fact, we also have the international commitments such as United Nations Sustainable Development Goals. So we also have World Health Organization One Health approach. So we also aim to achieve net zero or climate change obligations by the year 2070. So in this also, women have an instrumental role, and we wanted to become a $5 trillion economy very soon, and we wanted to become a third largest economy in terms of GDP, and we wanted to become Vikasit Bharat by the year 2047. So to achieve international commitments, to achieve the goals that we already set in, women's contribution, women's participation, their empowerment financially, politically is very, very important, right? So we need to achieve gender equality and we need to empower all women. And in fact, we could also implement the JIPA system. So this JIPA system has been followed in countries like Rwanda, where more number of seats are reserved for the women, and that has substantially increased the representation of women in the in political representation of women has been substantially increased in African countries like Rwanda. And it is also very important that we need to promote the inner party democracy, that encouraging internal elections for various positions within the political parties, and we should also elevate women in the local bodies as well, so thereby providing opportunities for women in local governance to serve at a higher levels in state assemblies and parliament. And in fact, recently the government has the parliament has provided 33% of the reservation for women through 106th Constitutional Amendment Act. So this is also known as Nari Shakti Vandana Abhinayam. And in fact, what are the key features of the 106th Constitutional Amendment Act? So as it has provided 33% reservation for women in the Lok Sabha and the state legislative assemblies, right? So it has inserted Article 330A, so that talks about reservation for women in the Lok Sabha. 332A, reservation of women in state legislative assemblies, and 339AA, so it talks about reservation of seats for women in the National Capital Territory of Delhi, and Article 334A, so it talks about reservations to become effective after delimitation is undertaken and census is conducted, right? And so this is very, very important provision, and that you should actually remember this provision. And time period, so reservation to be provided to 15 years, and it could be extended as well initially. And reservation will be implemented on rotation basis after each delimitation, right? So you can also go through arguments in favor of and arguments against the delimitation. For example, reservation, so it is considered as a vital step towards gender equality, and it also considered as a broader range of perspectives, or taking into account the broader range of perspectives when it comes to decision making process. And it also helps eliminate discrimination against women in political and public life. And when it comes to against the 33% providing 33% reservation for women through Nari Shakti Vandana Abhinayam, so delimitation based on 2021 census yet to be conducted and is mandatory. No women's reservation in Rajya Sabha and state legislative councils, and this is also another argument against providing 33% reservation for women, right? So that's all in this lecture, and thank you so much. In a next lecture we'll discuss some more important topics. Until then,